What I'm going to do here tonight is primarily try to educate and answer questions and fill people in who may be unaware of what's going on economically, unaware of what's going on with their bank, unaware of the consequences of the October 2008 bailouts, and introduce you to us at Butler Liberty Law, and hopefully just give you a little education on foreclosure, evictions. If it turns out that you end up being our client, great. But really what I want this to be is primarily a public service. Tell you what's out there, because it is rough. It's a rough playing field, and you really have to know that whether or not you get associated with us. So the title here is Turning the Tables in Foreclosure. This is where we're going to go tonight, with who we are. We'll go over some foreclosure basics, some eviction basics. We'll talk about how we got here, mortgage loan basics, and then kind of what we're doing as a law firm and where we've been. Okay, this is me. This is at least what Federal Judge Patrick Schultz thinks of me. Butler attracts clients through a website that blatantly misrepresents Minnesota law and attacks the legal system, the banking system, and other targets. Butler has been quite successful in attracting clients who either do not know or do not care that he has never actually wanted to show me the note. I got to address that. The fact of the matter is there's one case in the history of Minnesota law and one case in the history of mortgage securitization law that I'm aware of, and I won it. And we'll get to that later, but it's a case called First National Bank of Elk River versus IMS. And it was a declaratory judgment action where I was representing a bank. And I voided 2 securitized mortgage assignments. Now, it wasn't a show me the note case, and none of my cases are. But anyway, we'll get into this in a little more detail. I just want you to know, I should preface this, and I may be doing this a little tongue-in-cheek and a little early, but for people out there who haven't heard of us and aren't aware of the attacks that have been made against me, these are some of them. The federal judges, we had in what I call Quiet Title 1.0 cases, we had 22 cases with 197 clients that went into federal court, and we were 0 for 22. I lost all 22. All 197 clients at least lost their quiet titles. That's different than being evicted from your house. But we lost. And the federal judges really started to not like me very much and made some pretty serious charges against me. And so if any of you become clients, I want you to know very specifically what these fellows have said about me and ladies have said about me. When Butler's claims are finally challenged on the merits, he makes false representations and spins out contradictory and often absurd arguments in the apparent hope that their sheer weight and number multiplied by the number of parties and claims will overwhelm his opponents in the court. Well, let me address that. None of my claims have ever been challenged on the merits, at least in federal court. They've all been dismissed on what's called a Rule 12 motion on the pleadings. We've never gotten to the merits. We've never gotten discovery. We've never been allowed to to lift the rock on any securitized mortgage in federal court. And so that has just never happened. And this is where Judge Schultz is actually kind of nice to me, because he says, Butler's actions are not the result of negligence, but Butler is a very smart and very aggressive lawyer. And then at the end here, what happened in our first version of Quiet Titles, I walked into Judge Schultz's courtroom at 7:30 in the morning, I think in March of last year, and without any hearing or anything, he said, Mr. Butler, come to the podium, and for 3 hours, he grilled me on my complaint, and I explained to him exactly what I'm going to explain to you. hear about securitized mortgages and quiet title law. And at the end of it, he, as you can see, sanctioned me $50,000. I haven't paid it, and I never will pay it, and I don't have the resources to pay it. But you should also know that sanctions in courts, if a lawyer does something, it kind of breaks the rules or does something blatantly dishonest, there's a procedure for that, and usually it's brought by the other side. Prior to that, not one lawyer of any bank brought any sanctions motion against me. Why? Because I think they know the truth. They think they know that what I'm going to tell you tonight is correct. But for whatever reason, whether it was because we were representing such a burden on the federal courts or what, I don't know, but that was a start of a very, very bad spell for Butler Liberty Law, getting sanctioned $50,000. And it wasn't just Judge Schultz. Judge Ann Montgomery, she sanctioned me too, said Butler's insistence on relitigating losing arguments is staggering, and it comes with a cost because it multiplies the expense of litigation. And this is what disturbs me, but I don't, and monopolizes scarce judicial resources, as though you're not paying for that. Moreover, no one, not even Butler, can reasonably or competently believe in the merits of any of these arguments. Yes, I can. I won a case. I won a case called First National Bank of Elk River versus IMS involving two securitized mortgages. I can legitimately believe in the theory that was attacked here. And then, as you can see, she went on to sanction me too. And Butler's refusal to dismiss a complaint, which never had any hope of succeeding, as well as his filing of frivolous remand motion, deserves sanctions. Plaintiff's entire claim in this case is based on a legal fallacy that plaintiff's counsel, William Butler, Esquire, has doggedly refused to acknowledge. Butler has invoked a cruel arousal of unrealistic hope in his clients, all of whom face foreclosure and for whom this is an extremely emotional issue. There. If you sign up as my client, don't say I didn't warn you. Why are we in the foreclosure crisis? Thy silver is become dross, thy wine mixed with water. Our money is being destroyed before our very eyes. Our money has become disconnected from anything from real value, and this started, of course, with the establishment of the Federal Reserve in 1913 and really went off the rails starting in 1971. As a result of that, this is just truth. Thy princes are rebellious and companions of thieves. I mean, is there anybody who has any trust in elected officials? Those are our princes today. These are the people who signed the October 2008 bailouts. These are the people who rewarded the banks that created the problem and then tried to paper it over with printed money. And this is the problem. Thy money has become dross. Thy money has lost its value. And mark my words, we will come back to a system that has sound money. It will happen. This is proof of Isaiah 122. You can see the loss in the purchasing power of the dollar from 1913 down to today. And if you really look at 1971, and I'm going to get into a little bit of a moralistic argument here, and that's really why we're doing what we're doing, is because the wheels came off the cart in this country morally in 1971. People have lost their compass, and particularly lost their compass as of 1971. I would love to do a timeline of all the just horrendous things. And really sadly, coming to this realization for people is sometimes a very, very difficult thing. Every day I deal with and represent people who are just waking up to this fact. As the dollar loses value, and you realize, and these people realize that, oh my gosh, I've been participating in a system where I've been chasing these dollars or doing things for these dollars, And it really isn't me. I'm not, fulfilling myself. I'm not doing what I needed to do. And that's what happens in a funny money system. Bubbles get created. The government says, we're going to subsidize housing, so I'm going to go be a carpenter. I really want to be an artist, but the money's over here. And then all of a sudden, the bubble pops, and my wife looks at me and the 3 kids, and I'm economically displaced. I can't tell you the number of poor fellas, especially guys from 45 to 65, who come in my office beat down, who think they carry all this guilt of, oh, I'm a loser, I'm a terrible guy. You know what? No, you're not. Somebody was sticking a shot of vodka in your orange juice every single morning in causing you to make dumb economic decisions. And that is evidence of it. Everybody in this room is a victim of that. And until we can get back on track and get the wheels back on the cart, we're not going to stop fighting. For the people out there who think that, and a lot of people who are of my bent, I'm an Austrian economist worldview kind of person. There's a lot of people out there who think that we're on the upswing right now, that because the Federal Reserve printed a whole bunch of money, things are going to get better. Look at that. If you measure production in something real, gold, we're down and we're going down. And the quicker people wake up to that fact and say, okay, I've got to figure out what God put me on this earth to do and just start doing it, the better off we will be, and the quicker we will start going upwards. This is my pet project of valuing things in gold, and this values the stock market in terms of gold. And let's say the stock market goes to 30,000 tomorrow, and the New York Times and the Star Tribune says, hey, awesome, the stock market's 30,000, happy days are here again. What you're going to see there, if you measure that in terms of gold, you're going to see gold probably get to $30,000 an ounce, and then loaves of bread are going to be $30. But it takes time for that to happen, and it's a product of the manipulation of the money that has no basis in value. This is a really interesting one, actually. I kind of want to explain this. M3, the Federal Reserve measures money, and this is for those of you who are feeling guilt for not making a payment on a securitized loan that was originated from 2001 to 2008. Lose it right now. This chart measures M3. M3, it's a measure of money that the Federal Reserve discontinued in 2006. First of all, what is M3? M3 is the kind of money that essentially gets created out of thin air, like a credit card. You get a new credit card from Capital One, and bing, now all of a sudden I go charge $20,000 on it, and $20,000 more is created in the economy. And you can see in 2006, M3 started to go off the charts. And my opinion is what happened is the people who have the license to print that money, Citibank, JP Morgan Chase, the big national banks, they were getting into securitizing loans so much that chart went exponential, like off the charts. And the Federal Reserve said, oh my goodness, we've got a problem. And so money was getting printed, created out of thin air, and there was no oversight. The banks are subject to what are called reserve ratios. They can create that money, but it has to be within certain limits. Like if they've got $10 in the deposits, theoretically they're limited to loaning out 100. It's a 10-to-1 ratio. I think, again, the wheels went off the cart in terms of credit created money in 2006, and that shows it. This is basically a residential foreclosure in Minnesota, and kind of the timeline. We get sometimes clients who think that if my sheriff's sale is tomorrow, that I'm going to be evicted the day after tomorrow. And so we just want to kind of lay out for you the timeline so you kind of understand what it looks like. Starting with stop making payments, or you can't make your payment on January 1, you'll generally get a notice of default. That's a letter from your bank saying you're in default, also saying we're hereby accelerating amounts due. You'll get that around March 1. If you don't cure that, if you don't make that $20,000 payment or whatever the total amount outstanding is plus attorney's fees, then you can expect to get a notice of foreclosure on April 15th or thereabouts. These are kind of rough timelines. One thing I want to note this is a very, very important point for Minnesota foreclosure law. And we actually have a client here, Richard Proctor, who is victimized by this. That notice of foreclosure has to be personally served. That means they have to have a process server has to come out and actually visit you face to face. Are you Richard Proctor? Yes, I am. Then here, take this notice of foreclosure. And it's an important, a very, very important piece of the puzzle, because what I'm talking about here in Minnesota is what's called a foreclosure by advertisement. It is a non-judicial process. There's no courts oversee it, no courts overlook it. You don't have any right to cross-examine any evidence while you're in the process. You know, you're basically getting steamrolled. And the reason that notice of foreclosure has to be personally served is because in the deal the banks made with the Minnesota legislature when foreclosure by advertisement was allowed is that, well, if you're going to do that, you've got to get personal jurisdiction over average Joe. So if we're going to let you kind of play rough, then at least you have to give Joe notice just like you're serving him a lawsuit. Now, if that didn't happen to you in a foreclosure, you've got a weapon. You've got an issue. Now, service like a lawsuit, it doesn't mean that you actually have to be served. If there's a competent adult at your house, even a 16-year-old kid, and they serve 16-year-old kid, does Joe live here? Yes, he does. That's service like a lawsuit, and that's good. But they can't say that, we just didn't find him, everything's kosher and good, and go ahead with the foreclosure anyway. And it happens. If they do that, they've violated the personal jurisdiction issue, and that foreclosure should at some point be determined to be void. Very important issue. So the next step is a sheriff's sale. What happens there? At a sheriff's sale, that's a pretty significant legal event if the foreclosure is valid, if it's being conducted by a valid lender. What happens at a sheriff's sale is, say you are in title and you're here, and you have your bank, which has a hook in the property, which is a mortgage loan here. At the sheriff's sale, that switches. Now, the bank is essentially the owner, and you have what are called equitable rights of redemption. So they come in and they bid in a debt. Say, you owed legitimate lender $300,000. They show up at a sheriff's sale, and they give, no money exchanges hands, by the way, with an original lender. They will show up, a process server will show up at a sheriff's office with a pre-prepared sheriff's certificate of sale saying, average Joe owns legitimate lender $300,000. Here, auction this off. Nobody else shows up because there's a long period of redemption. And the sheriff sells the house to legitimate lender for $300,000, and then the positions switch. So now legitimate lender is essentially the owner, and the only way for you to switch that back is by paying him $300,000. And what you have in here, it's called a redemption period. So after that sheriff's sale, you have 6 months to do that. And again, we're talking a general residential foreclosure in Minnesota. If you have farmland, that can be like 12 months. But if you're talking a general residential foreclosure, you got a 6-month period of redemption. And I say legitimate lender because it's my view that if you've got a securitized loan and this hasn't been resolved fully to, I think, anyone's satisfaction, that if BAC home loans, for example, who you never borrowed any money from, who never had an interest in your mortgage, and doesn't have a contractual relationship of any kind with the ultimate owner of your debt, if they show up at that sheriff's sale and bid in a debt, I think and this is Bill Butler talking, I'm sure there's many federal judges who will disagree with me, that there's a problem with someone who doesn't have any connection to the debt showing up at a sheriff's sale and saying, Joe owes me $300,000. That's part of the reason, that we challenged securitized mortgages in the way we did in, again, what we call Quiet Title 1.0. And then you come down to the end of redemption period, so you get down 6 months. And then at the end of the redemption, now that is nail-biting time. That's scary time. You are potentially facing an eviction soon after December 15. Now, this is what happens after that end of redemption. This is Eviction Basics, Eviction 101, and it doesn't get any rougher than this. In Minnesota, it is wham, bam, thank you, ma'am. There are a number of clients here who've been evicted, and there's nothing we can do. There's almost nothing we can do if the judge decides, listen, I want to will an eviction here. There are things we can do to stop that, and we're hoping we're going to be more successful, but I will tell you today on a new quiet title case that I had, which is perfectly lined up with what I call Quiet Title 2.0, I had a judge who said, no, I'm not going to hear any of it. I'm going to evict your client. So and there's not a lot of rhyme or reason to that, unfortunately. I'll tell you, there are good arguments that we have for stopping them, but they're no guarantee. But anyway, so here's what evictions look like. You get service of a summons and complaint, but now this is different. Remember we talked about the notice of foreclosure where you actually have to be physically served or served like a lawsuit? Now this is different. The service of complaint and an eviction. They can show up twice at your house after 5 p.m. You're not there, they can tape it to your door. So if you're out of town for a week and you miss it, you are going to have a rude awakening because you're going to come home and find a summons and complaint taped to your door, and you're going to have to show up in court on January 15th. And the standard in Minnesota is it's a rubber stamp procedure. We have presented to courts, we have shown courts that eviction is completely void, that there's 2 robo-signers or 3 robo-signers in the mortgage. We've had private investigators pull up documents and say, you know what, this person says they work for Bank of America, but you know what, they actually work for lender processing services. This person says they're a vice president of MERS. They're not. They're actually a low-level employee with Bank of America. And we provided that to the court and said, you can't evict this person from their house. This foreclosure is completely void. There's robo-signers all over this. People have I've had a private investigator look at this. Nope, you're out. So this is what you do not want to be in, but you have to know if you decide to get in a fight, whether you go with us or with anyone else, what it looks like. So you have your first court appearance, and you see very shortly thereafter, sometime if you're unrepresented, you might get a writ eviction on the day you show up. Between 15th and the 22nd, you might get a resolution, and we're really talking kind of a negative resolution here. So in that time period, we're assuming you're going to lose. Then what happens is the judge signs an order, says, I think this bank owns this house. I don't like any of these defenses. I don't think they're legitimate. And so therefore, bank gets the house, and bank is entitled to what's called a writ of execution. And the writ of execution is just a document that the district court issues. The lawyers, the bank's lawyers pick it up, and then they toddle it over to the sheriff's office, and that's the green light to the sheriff to come kick you out. And the second part of this timeline is never very predictable, because now you're talking about the sheriff's schedule. It has to be fully executed, I believe, within 30 days. The writ has to be delivered to the sheriff and acted on within 30 days. So what that looks like is you're entitled to 2 sheriff's knocks. The first time the sheriff comes up, he knocks and says, "Hey, sorry, you're getting evicted. I've got a writ here." And what that's called is a 24-hour lockout notice. We tell the client, listen, if that sheriff comes the first time, act as though it's really going to be 24 hours. It rarely is, but you should be prepared for that eventuality, and knowing that you actually will have a period of time to get back in the house. I think it's 30 days. But if you get that sheriff's knock, it's time to pack up the backpacks, plan for 2 weeks of, okay, I'm going to go to extended stay, or I'm going to go stay with my relatives or whatever. And then also, if there's any portable, super valuable stuff, when that first sheriff knocks, then have that stuff and get it out of there, or have it be able to get out of there. Then lockout. The Minnesota law says that the bank has to give you a written notice of the lockout date, but it's a law without teeth. So you can get locked out without getting a letter. You can't, that's why we tell people, if you get that first knock, be prepared to go out and get out within 24 hours, because even though the law says you show up and, hey, I didn't get a letter, and nobody's going to do anything about it, and there's no teeth behind it. So, but if you're still in the house when that sheriff comes the second time, he gives you 10 minutes. So get out. I've been sadly on the other end of the phone with a client, and he's going, what do I do? What do I do? I said, get out. That's the sharp end of the stick in an eviction, and again, you don't want to be there. I'll just address, before moving on, what we do in this process and how we can be effective. There is a case called Bjorklund v. Bjorklund Trucking. It holds that if you've got a title action pending and your opponent in the title action brings an eviction action against you, so you've got title action here, and then they come over here and bring an eviction action, that it's an abuse of discretion for the judge in this eviction action not to stay this until this gets resolved. And stay just means hit the pause button. And it makes sense, as I tried to explain to a judge today who was not buying it, by the way, so know that this doesn't always work. Even though it is, it's just, to me, it's 2 + 2, not only law, but common sense. What you have in a title action and an eviction action is, one's a fight over title to property, and one's a fight over possession of property. And as I described it to this judge, and which is true, is title is like this. Possession is inside of that. You can't have possession without title. My opponent today was successful in doing is persuading the judge that no, possession and title, they're different. To me, that's absurd, and it doesn't accord at all with Bjorklund v. Bjorklund Trucking. And by the way, there's another case out there called Nedashovsky, which the banks cite for the proposition that it's not an abuse of discretion to allow an eviction to go forward while there's a pending action going. But the difference in Nedashovsky is the other action wasn't a title action. It actually was a money damages action over here. And so we had a possession of real property, and the Nedashovsky plaintiff in the other action was bringing claims under the Minnesota Deceptive Trade Practices Act. So that's I want money thing. And so as I don't want to, again, dump on us too much, because we're usually pretty successful in explaining this to courts that that's different, isn't it? So it made sense that the judge in Nedoshavsky allowed the eviction to go forward, because that didn't at all harm or hinder the other action, because the plaintiff and defendant in the eviction action was just seeking dough. And so there's no inside the circles fight over title and possession of real property. There was a fight over money and a fight over possession of real property, and so it was apples and oranges. Whereas at the Bjorklund case, we're talking about fights within the same circles, title and possession. And so at some point, we've also been up the Court of Appeals on at least 2 cases where they have not accepted that analysis, but we're going to keep banging on the door. It's just truth. So we will keep hitting that. And again, if you become one of our clients, just know that that's a risk. If you get to an eviction, you're gambling on a judge. Okay, so now we're going to turn to just some mortgage loan basics. This is an old school mortgage loan. You got your borrower, average Joe, and then you've got a lender. If anybody's ever seen the It's a Wonderful Life, it's Bailey Savings and Loan. You went to George Bailey and said, George, I need a loan. George said, okay, here's $100,000. I'm going to take a mortgage in your house. So you showed up at the closing. You signed a promissory note to Bailey Savings and Loan, and that's your promise to pay. And then you also signed a mortgage, which is security for the promise to pay. And 10 million years of real estate law will inform you that a note is a promise to pay. It's a negotiable instrument. And a mortgage is security for that promise to pay. A mortgage without a note is nothing. That's been really twisted in Minnesota law, but it's still true. Okay, so this is a securitized mortgage loan. Now you have a borrower, average Joe, and of course, since we're in Minnesota, we have above average Joanne. And then it gets more complicated on the lender side. We've got a mortgagee, you may have heard of like MERS, and or the original lender. We've got a lender who can either be the actual lender or can just be, someone like Joe's Bait and Mortgage Shop, just a mortgage broker, somebody who just showed up at the table who was fronting for someone with the real money. And then ultimately you have the real lender who is a mortgage-backed securities investor. Okay, this is how a securitized loan works. Joe and Joanne sign a note and mortgage, and they sign it to whoever's across the table from them. That might be Joe's Bait and Mortgage Shop, it might be Citibank, it might be Bank of America, Countrywide, whomever. And then it goes into the pooling and servicing agreement. This is a securitization document. Within that pooling and servicing agreement, there are several entities. There can be a sponsor, an originator, they're called different names, so we just dubbed them Entity A and B, and then a depositor who ultimately deposits the loan with a trust. And there's a trustee who's in charge of the trust. The mortgage-backed securities purchasers, these are the Wall Street pension funds and whatever, they're pumping money into the pooling and servicing agreement, and they want to know that their mortgage-backed securities are backed up by something, that there's something real that I'm buying into. And the way these agreements are set up is that to give the mortgage-backed securities purchasers assurance that what they're buying is real, the pooling and servicing agreement sets up a trust. And they say, listen, dudes, see, we did this, we've got this all right, we've dotted our I's and crossed our T's, all the notes and all the mortgages, there's 40 billion of them here, and we got them all in a trust, and they're locked in a safe in Delaware, and you're cool in giving the money to us and passing it through to average Joe and Joanne because we got their notes and their mortgages in a locked box somewhere. I like that graphic because it really explains what goes on. But the important part of this, and this is what I've explained to the federal judges who, I spent 3 hours explaining this to Judge Schultz, who said those nasty things. But in order for that note and mortgage to be valid, or for someone to foreclose on it, if that trustee is foreclosing on it, for example, then what has to happen according to the pooling and servicing agreement, these arrows from A to B to C or to D to T, those arrows represent terms of the pooling and servicing agreement, say that both the note and the mortgage have to be transferred to A and B and depositor to T. And it further says, the pooling and servicing agreement, that those entities, while they have those notes and mortgages, have legal title to them. It's a big deal. Nobody ever sees this of record, but this is a chain of title. And if T is holding your note and mortgage, and they weren't endorsed by A, B, and C, or there aren't assignments of mortgages, then there's a problem. There's been a breach of the pooling and servicing agreement, and my argument with federal judges is they will come back to me and say, well, so what? So what? You're not a party to that pooling and servicing agreement. You don't even have standing to make that claim. That's all a bunch of Wall Street mumbo jumbo. But the fact of the matter is, if trustee shows up at my sheriff's sale, what does he do? He bids in a $300,000 debt due on a note. Okay, well, what if that note is sitting with entity B? And what if entity B sues me 3 years later on a $300,000 claim? Where's my recourse? Because all that foreclosure stuff we talked about, remember the deal between the banks and the legislature, we're going to let you do this outside of the judicial process. We're going to give you the privilege of doing this. And so it is a big deal. And it's not just a theoretical deal, because we've had clients on second mortgages. Actually, Matt had a second mortgage where he got sued by a lawyer who allegedly held the second mortgage, and then someone else called him up and said, hey, I got your second mortgage. You want to settle with me? And so we actually said, sure, let's settle with him. And then let's slam the lawyer upside the head. Because it was, I think it was Citi, had sold the debt twice. So it's not just theoretical. And by the way, Minnesota Attorney General, I think yesterday or the day before, came out with some big press release that she's going to go after or support legislation that will require kind of the little dog bill collectors to prove up ownership of the debt prior to making claims on credit cards. I think Midland was one of her targets. Well, okay, great, Lori, but what about Citibank? What about J.P. Morgan Chase? Why don't you go after the big dogs, right? That's what we're doing. This is a representation of a securitized loan. The green level is what you see. You show up at a closing, you borrow $387,000 from you think Countrywide, and you sign a note payable to Countrywide, and then you sign a mortgage also to Countrywide, but sometimes there'll be a third party, what's called a nominee, maybe MERS. So this is using a kind of a Countrywide securitized loan as an example. And then when you hit foreclosure, what there will be is, say, Bank of America acquires Countrywide. In order for Bank of America to commence the foreclosure on you, they've got to get an assignment to that mortgage, and they do. They'll have somebody from MERS, a MERS vice president, maybe a local lawyer, assign the mortgage to the client, Bank of America. Second level, you also see that. So this is a servicer. So this is who you pay. And if you went back to that other slide, that was the servicer in that big bubble They're kind of the chief operating officer of a pooling and servicing agreement. They make securitization go. They collect the dough, they pass it out to the mortgage-backed securities purchasers, and so that's who you pay. And that can differ than the green level. You can have 5 or 10 of these servicers and sub-servicers at the red level. And in this case, we've just used, it went from Countrywide to BAC Home Loans, and then ultimately to Bank of America. This final level is what you don't see. You don't see this securitization part, this kind of purple in the middle. These are the, if you went back to that other slide, the A to B to T. So these are the entities that had interests, legal interests, in your note and mortgage. And the securitization documents will always require that the note be endorsed by AmeriQuest Mortgage and also then be endorsed by AmeriQuest Mortgage Securities, Inc., and then by Bank of America as trustee. And it would also require that there be assignments of mortgage to all of those entities. And again, remember, that's what the mortgage-backed securities guys, the investors, they said, we need that. If anybody's touching this stuff, we need to know that they've signed off on their title. And then sadly, at the end, what's really happened as a result of the October 2008 bailouts is Fannie and Freddie, I think, are in on about 80% of all securitized loans now. The FHA is originating loans. They're trying to prop up the real estate market. It's Isaiah 21, 22 time. They're just printing money as though that is going to somehow make gravity not work. It isn't going to work. And so Fannie and Freddie's under the rug on lots of mortgages, and I argued a case at the Court of Appeals today too. That one actually went well. But my opponent in that case got up and said, oh, Butler started this quiet title 1.0, and he didn't even raise this theory in this eviction that he's defending now, this idea that Fannie Mae should have had an assignment of mortgage to it and that the foreclosure is void. And I said, well, yeah, because guess what? Fannie didn't show up. They weren't even up, they were never in the green level until, so I started the quiet title, way in the green zone. And when it came eviction time, all of a sudden Fannie popped up its ugly head. Oh, we're the owner. Oh, really? How did you get title? And in that case, it was a quitclaim deed for $500. So how does that happen? How did Fannie acquire a $300,000 house for $500? And they're cheating on deed taxes when they do that. And that's the Hennepin County attorney is actually going after them for that. Now, this is the response to all the attacks at the beginning. Butler does this. He makes up these silly claims. He's got no basis in law or fact. I'm not sure if any federal judge out of those 22 actually cited the statute that we proceeded under. Maybe, I think Schultz did actually in a footnote, but that was the whole case. It is our case. Chapter 559 allows for a quiet title action. If you can see the bold, anyone may bring an action against another who claims an estate or interest therein or a lien thereon adverse to the person bringing the action. Frivolous, I guess, right? What a nut job. So this is a quiet title case from 1880. And this stuff goes, this is Judge Schultz, he threw a couple of these cases in a footnote and said, oh, that law is just so old. Okay, well, old law is good law to me. So this is just one. This is the recent 8th Circuit decision that was favorable to us. Again, we had 22 quiet titles. We lost 0 for 22. The first one that the 8th Circuit decided, they reversed. They said, Butler, you stated a claim, but it's not as good as it sounds. They hated about 85% of the complaint. They called it Show Me the Note and said, but we think you stated a claim for unrecorded assignments of mortgage and robo-signers, and so we'll send it back down to the district court. So there's a big celebration up in the office. People were like going nuts, like, oh, we won, the $250,000 of sanctions will go away, which they will as a result of that. So that's a big weight off the shoulders Chief Judge Arnold of the Eighth Circuit says you stated a claim, so the sanction should go away. But it really is kind of a backhanded, the way they wrote the opinion, they basically said, okay, we're gonna let this guy's neck out of the noose, and we're gonna send it back to the district court, and so you can screw him good. And so what we're going to do with that decision, even though we won, we're going to petition for review to the U.S. Supreme Court, because we're not going to accept a crumb, and we're not going to accept a half a loaf. So that's Murphy v. Aurora. That was the big win that we were kind of, bringing people in here to celebrate. But it became apparent to me in the last week that the federal district court is not going to celebrate it as a big win. It went back down to the district court. I had a scheduling conference Monday. Okay, I won, right? The local federal district judge says you don't get discovery. You don't get to take any depositions. They get their next bite at the apple against the Judge Murphy or Judge Montgomery, who said those nasty things. So I'm not real optimistic that I don't want to be negative, but I would be very surprised if Judge Montgomery says, yes, okay, I accept there's a claim here. But if she doesn't, we're going to be very prepared. It's going to get reversed again. Okay, these are other cases, other quiet title cases that basically say the summary of these cases is that in order to start a quiet title action, that you just need to be in possession of real property and allege an invalid lien on the property. This is old school stuff. And then, like the case I tried, the First National Bank of Elk River versus IMS case, the party asserting the lien actually has the burden of proof in that case. They've got to come in and show up their lien, prove up their lien. And it dawned on me when this whole securitization, this whole mortgage crisis occurred, and I talked to some friends of mine who are securitization experts. I said, you know what, they can't prove it. And the deeper I got, the more I'm convinced they can't prove it. That transfer to A to B to C to T never happened. It never happened. And a quiet title allows you to lift that rock and say, show me all the bugs. And if the bugs don't perfectly align in your favor, then you have to go away. You don't have a lien. You might have a note, and you can sue me on the note, but your mortgage is gone. And then we can have a fair fight. You guys took trillions of dollars in 2008 bailouts. Now you don't have a mortgage. Let's fight. Fair. So these I don't think any federal judge in any of those 22 cases cited any of these cases. Maybe Schultz did. I know that none of them have cited, or I don't know, but I'm 99% confident that none of them have cited Alt v. Graf. That's the burden of proof case. This is the burden of proof in a quiet title. This is, you saw the first screen, turning the tables. A quiet title turns the tables. It requires them to come in and show that their paperwork is correct. And that's why the federal courts hate these, because it turns the tables. And it will require a lot of work on the banks to prove up their position. Is that nasty of me to do? I don't think so. I would love if they would all come to me and negotiate. We could probably come to a reasonable number for clients. But that is the law. And that's just the site to First National Bank of Elk River versus IMS. It's linked on my website. You can pull up the case. You can read the case. You can see what I argued to federal judges, every one of the judges who dismissed my cases and sanctioned me. I said, these cases are no different than First National Bank of Elk River versus IMS. The federal judges say, you're saying, show me the note, show me the note. I'm saying, I don't care if they show me the note. If they don't show up with the note, they lose. Just like in that case, I was representing First National Bank of Elk River. Independent Mortgage Services had 2 recorded assignments of mortgage. They said they were the owner of the mortgage. We said we were. We had notes, we won. They didn't, they lost. Simple. The Murphy decision said, and this is a difference between what we're doing before and what we're doing now. The Murphy decision said, okay, Butler, you stated a claim when you say that there are unrecorded assignments of mortgage and there's robo-signers. And again, I'm fairly characterizing it, it's a 10% win. But as I explained to two courts today, it's still a 100% win, because the purple blue level down there, that's the disease. Okay, that's the disease. I've been talking about that forever. That was all Quiet Title 1.0. That was pre-Murphy v. Aurora. I was talking about the note wasn't assigned and Fannie Mae doesn't have any right to enforce the note, so what are they doing? Showing up at the sheriff's sale or even Bank of America. The note wasn't endorsed. They don't have any right to show up at the sheriff's sale. That's the disease. The note is what drives a real estate transaction. Federal courts have sanctioned me for using the four-letter word note. So Murphy now says, well, if you talk about unrecorded assignments of mortgage and robo-signers, you may have a claim. Well, that's just a symptom of the disease. In every single securitized mortgage case where there's been a bad transfer of a note, there is an unrecorded assignment of mortgage and there's a robo-signer. And so we'll show you in a minute kind of some of our work. And that little line at the top, that assignment of mortgage, is always, that's the devil right there. That's always where the problem is. Because imagine you're Bank of America and you're holding a big bag of countrywide crap and your notes aren't endorsed, your mortgages aren't, you don't have assignments of mortgage, but you got to foreclose. Well, in order to foreclose, I got to have an assignment of mortgage to me. And then you look around the room at all the, suit vice presidents and say, who's going to sign the assignment of mortgage? Not me. That's bank fraud. So what do? You go hire some 16-year-old, and then you get her to say she's a vice president of MERS, and hey, China Brown or whomever else, sign this assignment of mortgage to us. And so it's there every single case. We pull up 500, or not 500, but probably 250 doc outlines, which we'll show you in a second, and they've all got that flaw. So the symptom is everywhere the disease is, and so even though Murphy is a 10% win on its face, it's a 100% win. Okay, and I have to address this because there was a case called Jackson v. MERS that was decided, I think, in 2009, and it was a long case, and I had so much difficulty explaining to so many judges why it had no applicability to my cases, but I do want to address it here. And I still don't think it has any applicability. It wasn't a quiet title action. There was no Chapter 559 action. There was no Alt v. Graf burden of proof switching element to it. There was no bank defendant in that case. But it was a long discussion of Minnesota law, and it was a long, this is the way the Minnesota law works. And there are two things that I'll just go public with that I think are incorrect about the decision. Even if it is the law, these are what it says, but I think that they have no basis prior to Jackson v. MERS. And I'm confident in that. I've read every case in Jackson v. MERS. The first one, that a mortgagee need not have an interest in the note in order to foreclose by advertisement. What that would mean is, if that were true, and that, again, that's what Jackson v. MERS says and has been interpreted to stand for or be the holding. If that were true, that would mean that a complete stranger to the note, okay, you signed a note to Countrywide for $300,000, and then Daffy Duck showed up at your sheriff's sale and bid in $300,000. Daffy had no interest in that note. So, and there's no support for that. There's a couple of cases in Jackson v. MERS. There's a Botno case and another case, I think, where maybe a lawyer was acting as an agent for the note holder and he foreclosed, but he was clearly, and he was of record, an agent. There is, it's okay for an agent to foreclose. Like, for example, MERS potentially could foreclose if we're an actual agent, if we're actually operating on behalf of a note holder, but it isn't. And so that, I think, is incorrect. The other thing that we haven't challenged, and we never will, but I just want to go on record, it says that the note does not follow the mortgage in the sale or transfer of a note. Now, this is kind of legal arcane stuff, but every single pooling and servicing agreement that was established is covered by a legal opinion by a law firm. The biggest law firm that did this was a law firm called, I think, Layton and Fingers, or Fingers and Layton in Delaware, that signed off and said to all the mortgage-backed securities, it is our opinion that the mortgage follows the note. So you don't need to worry about those green levels, that only the mortgage is of record and all these transfers happen down here. You're secure, because it's our opinion that Minnesota law and every other law in the state, or every other law in every state in the nation, says that the mortgage follows the note. So it doesn't matter if I'm the of record mortgagee and I transfer the note to Talitha, to Matt, to Suzanne. When Suzanne wants to foreclose, she can foreclose. She's going to have to get an assignment of mortgage from me to her, but as the note transfers, the security transfers to her, even though there's a difference there. So it's still in my name of record, but she can feel comfortable that if she holds the note, that she's ultimately going to be able to execute on the security instrument. And that's just, that is just flat out wrong, but we're not going to challenge it. And this is the actual holding in Jackson. In Jackson, what the plaintiffs were saying is they were talking about those transfers of those notes, and they were saying that, well, that those transfers of the notes, they have to be recorded in accordance with the Minnesota Recording Act. And the court held, no, they don't. That's it. That's all that Jackson holds. Okay, this is why Jackson doesn't apply to what we're doing. It's not a quiet title action, not an action under Chapter 559. The burden of proof was on the plaintiffs, not on the defendants. No bank named as a defendant. No challenge to title. It was an attack on MERS and the splitting of notes and mortgages. That's not what we're doing. We'll just leave these up, and these are on our website. These are just some decisions that have rejected Jackson v. MERS. So we'll just leave these up. These are, in my view, sane decisions of courts, that judges that didn't get sanctioned $250,000 for making these decisions. And so this is, I'll just lay it out there. This is going to be our quiet title 2.0 theory. The Murphy court says unrecorded assignments of mortgage are in play. Unrecorded powers of attorney are in play. Robo-signers are in play. So that's what our quiet title 2.0 legal strategy is all about. But this is, if you come into us and you don't want to start a quiet title, but you kind of just want to know what's under, or not, you don't even learn what's under the rock in this, but you kind of learn what's going on with your loan and where we would see the flaws are. We do this up, we call it a document outline. When I'm looking at these things, I'm looking at that assignment area. There will be on this, if I looked at that, if we could read it, there would be 99.9% probability of a robo-signer or somebody without authority to execute that, in my opinion. And this is just a sample quiet title lawsuit. This is a quiet title 2.0 lawsuit. Yeah, so this is what we're after. I mean, all we're really wanting to get is, we don't want to get a free house, but we don't want Fannie to get a free house either. We're really trying to, get some old school due process, some pre-1971 sanity. And if we got through the door on one of these, I think more what's holding us back is, maybe I'm not a good voice or whatever, but there's a lot of fear. The courts are just fearful, and and that's a big problem. I mean, I think fearful of rattling the established order. The fear is, you know, for example, my first quiet title action. I went through this with I think it was Judge Donovan Frank, and he was listening, but his first response was, well, if Mr. Butler, if you're right, then everybody can do this. Yeah, it's not a legal argument, but that really was the basis of his decision, I think. He thought, well, gosh, if you do that, that's going to be a lot of work for me, one, and then two, you know, I'm not going to be, you know, Lance Ito of, you know, federal judges. I'm not going to be the bad guy who opened up the floodgates. And so that's what I think the fear is. For those of you who aren't nut jobs like me and follow the money, but this is serious stuff. This is what happened in 2008, and the storm that's coming, and you need to prepare whatever you need to do, get in shape, do whatever. But our monetary base tripled since 2008. And you go, well, what does that mean? You know, big deal. That just means there's going to be more money, right? No. What that means is that we're going to be faced with, or I suspect, unless there's something that they can do to curtail it, and they will try to curtail it, but we're going to be faced with some serious inflation. The way they've kept it under wraps so far is they printed all that money, but it's sitting with the bailout banks. Well, why aren't they lending? Because the Federal Reserve has done something called pay them interest on excess reserves. So you're a bailout bank and you're holding, say, $1 trillion, and you look out and you see no businesses worth lending to. But even if you do, the Federal Reserve says, hey, if you put that $1 trillion with us, we'll pay you 0.1% interest, or, you know, they pay them just a droplet of interest. But it keeps that money off of the streets. And they've been very, very effective in keeping that off of the streets for 4 years. But now, presidential election has happened, that money is going to hit the streets. And when the Federal Reserve wants to, if it flips the switch and says, banks, now we're going to charge you rent, that money is going to fly out. And loaves of bread the basics will go up. How will the government respond? Price controls, you know, blame the baker, things like that. And then stuff comes off the store shelves. But that is a serious crime that occurred. And we are going to see it in the next few years. I don't know when or how, but you need to be concerned about that. You need to, these dollars, you saw those charts at the beginning where dollar was losing its purchasing power? That is a real loss of purchasing power. When dollars get multiplied, they lose their purchasing power. If you're sitting, you know, on $100,000 in cash, get it in something real, or get it in some, you know, Iowa farmland or something. But be concerned about that.